My name is Devin Kagram. I'm a partner in the immigration team at Watson Farney Williams, and I'll be presenting today with Elliot Marsh, an immigration advisor in the team. We'll be talking about the key issues in the UK immigration system for the construction industry today. And the UK's immigration system has gone through a lot of changes post-Brexit with the loss of free movement, and it's impacted industries such as the construction industry quite heavily because of that loss of free movement. And now to employ non-British nationals or those who don't have a valid right to live and work in the UK, usually you need to sponsor, an employer needs to sponsor that individual. They have to register with the Home Office as a sponsor. And at the time of the introduction of this sponsor regime, which has been around since 2008, the Home Office also introduced a strict compliance regime and with heavy fines for non-compliance, which have increased substantially recently with a real clampdown anticipated on that. And this is a particular challenge for the construction industry, both of these aspects, because of the widespread use of subcontractors and agency staff. So today we're going to focus on that compliance regime, followed by some of the key challenges and issues around sponsorship, with a particular focus on how it impacts the construction industry. I'm going to hand over now to Elliot Marsh, who's going to talk us through the compliance regime. Over to you, Elliot.
Thank you very much, Devin. And I'm going to start by covering right to work checks for employees. And first off the bat, it's pivotal that you carry out your right to work checks for new employees on day one of employment, irrespective of their nationality. And not doing so would leave you open to some pretty serious risks that I'll cover in more detail shortly. So you should be checking the visa status of all employees online using the Home Office's new digital right to work verification system. And that allows you to now input a worker's personal information, so maybe their biometric residence permit number, and see an almost immediate digital confirmation of their right to work, which you should then keep on their personnel file. Importantly, you'll only have a statutory defence against a civil penalty if a right to work check has been conducted properly. And otherwise, if you haven't done it in line with the Home Office's guidance, you risk fines and further ramifications that could affect your wider workforce and your broader ability to conduct business in the UK. So it's important, in light of that contracts of employment would include right to work obligations that make employment conditional on holding the appropriate visa permission. So moving on to compliance for sponsors, and beyond those right to work checks, there are additional compliance obligations on sponsoring employers. That would include record keeping and reporting obligations for sponsored workers, so the need to monitor employees' absences and their visa expiry dates, reporting unauthorised absences, keeping an up-to-date personnel file, and really adhering to the documents stipulated by the Home Office at the time that you apply for the sponsorship licence. The real crunch point for that comes when the Home Office audit the business. Now, they can audit any business, whether or not you have a sponsorship license, but they have a particular focus on sponsors. Now, personnel files can be assessed by the Home Office during their audits, which should happen at some point during the 4-year lifespan of a license. And those inspections can also be triggered by things like a license renewal or by other activity on the license. So even things like updating office addresses and that sort of thing, that can put you on the Home Office's radar, and it would really increase the chance of an inspection being carried out. What we've noticed is that post-lockdown, when the Home Office ceased all audits, is that the Home Office has now resumed their in-person license audits, and they can be carried out either with prior notice, normally of about 10 working days, or they can just carry them out as a spot check without warning. And we have had a couple of clients who quite literally had a knock on the door at 5 p.m. on a Friday when the Home Office had just been in the area, and they wanted to drop in and interview people and have a look around. Moving on to the consequences of employing an illegal worker, and the reason why it's so important to be on top of immigration compliance. The Home Office has recently substantially increased its illegal working fines. So previously, these were $20,000 per individual who is employed without the valid right to work, and where the employer has unknowingly employed someone without the right to work. They've now doubled that civil penalty charge to £40,000. The ramifications, though, go far beyond financial penalties. The Home Office can name and shame companies on their website, and you'll see a number of household names have been publicly listed over the last decade. That covers the unknowing employment of someone who doesn't have the right to work. But if an employer knows or has reasonable cause to believe that an employee doesn't have the right to work in the UK, they are in fact committing a criminal offence, and the maximum penalties for that are 5 years imprisonment and an unlimited fine. Beyond that, significant compliance breaches, so things like record keeping deficiencies and information on a visa application not corroborating what's held in their personnel file, that can lead to the suspension or the revocation of a sponsorship license. And the ramification of that for the business is that your sponsored workforce could have all of their visas automatically curtailed, and you would receive fines. That would obviously have severe logistical, financial, and reputational ramifications for the business, and hence it's vital that immigration compliance in all of its forms is taken very seriously and really given the due consideration that it demands. I'm now going to hand back to Devon.
Thank you, Elliot. So Elliot set out the process and the penalties for failing to comply with the right to work checks for your workforce. And I think this is a particular challenge for the construction industry, and that's because of the makeup of the workforce. You typically get a lot of subcontracted staff, agency staff, and so the employment relationship can often be quite complicated. And strictly speaking, this compliance checks are required for employees, and the Home Office, defines sort of the employment relationship as a reference to employment is to employment under a contract of service, basically an employment contract, or apprenticeship, whether express or implied, and whether oral or written. So we have a straightforward employer-employee relationship. That's clear that you have responsibility to do the right to work checks. Technically, a company is not responsible for subcontractors' employees' immigration status, but the lines do get blurred, particularly where you have individual contractors or subcontractors. And, this links into the whole IR35 question. Who's the employer for tax purposes, who's the employer for employment law purposes. That will also have a bearing for immigration as well. And then you've got agency staff, and typically agency staff are provided in two ways. Where you've got the agency providing an introduction, and then the person signs a contract with you as the end user directly, there you would have responsibility for the right to work checks. Where they're simply supplying staff, but they remain the employer on a temporary basis, usually the agency would have that responsibility. But again, lines can get blurred here. And you've also got to think about the indirect consequences. So even if you don't have the legal responsibility to do those right to work checks, think about the reputational risk. Elliot mentioned the naming and shaming on the Home Office website. Well, often the press will pick up, so it could be someone in the supply chain or a subcontractor that's breaching the rules, but they'll pick up the big name at the top and splash that all over the papers. Also, think about workforce absences. We have anecdotally heard that where certain businesses get wind of a Home Office visit, large swathes of the workforce don't turn up the next day. And obviously, if the Home Office do and catch people, that's several people who might all of a sudden be taken out of the workforce at short notice. And the key is to factor this into your contracts. Where does that responsibility lie? Are there warranties? Are there indemnities for people failing to do the checks that are their legal responsibility to make sure that you are protected? Now, moving on, this also has an impact for those who hold a sponsorship license, this definition and complicated nature of employment. Now, as I mentioned, often you need a sponsorship license in order to hire individuals in the UK. And so the employer registers with the Home Office and sponsors its employees. And again, where you've got a straightforward employer-employee relationship, that's fine. But the Home Office have told us, it's not strictly in their guidance, but the employer does not necessarily need to be the sponsor of the individuals and doesn't have to be the one paying their salary. Specifically in the guidance, there is provision for hiring people who work on client sites. You get that often, for example, in the IT industry, where you hire people and they're at different sites working on projects, and a similar thing can happen in the construction industry as well. But the key is the sponsor has to be the body that's responsible for their duties, functions, outcomes, and outputs. So where there's not a straightforward employer-employee relationship, this becomes a lot more complicated. And moving on, there's two particular challenges for where you're hiring subcontractors. So the first scenario really is if workers are employed by you've got workers, they're employed by a subcontractor, but that subcontractor basically sends them to a site, but really has nothing to do with what they're doing on a day-to-day basis. They are not responsible for the duties, functions, outcomes, and outputs. There would be a question mark as to whether that subcontractor is the correct sponsor to sponsor that person's visa. The flip side, and this is much rarer, where you take the decision that it doesn't have to be the employer sponsoring. So effectively, the sponsor here is the end user, and they're going to sponsor the visa. But the subcontractor really is telling that individual what to do on a day-to-day basis. They're responsible for those duties, functions, outcomes, and outputs. In that case, the end user wouldn't be the correct person sponsoring. It really should be the subcontractor. So where you get this wrong, the Home Office obviously take a dim view. So you can see how it can get quite complicated, and therefore you've got to be mindful of these complications. Intra-group arrangements, you can see complications here. So often you have groups who have 2 UK companies. One's got a sponsor license, and you know, company A, company B is the one who's hiring someone who wants them to, you know, work on a project. Well, they might say, well, why doesn't company A hire them and sponsor them, even though company B is really dictating what they do on a day-to-day basis. Also, you've got a non-UK employer sending someone to the UK and saying, well, our local branch in the UK has a sponsor license, they can sponsor this individual. Well, it's not necessarily straightforward if that UK branch is not responsible for their day-to-day activity. So you've got to think about whether you need to add these other entities to the license. Is the license broad enough to cover these other companies? So how do you mitigate this risk? So moving on. So as I said, you've got to think, you know, before you sponsor an individual, think about what the structure is, what the relationship is, and make sure the right person is sponsoring this individual. And also think about putting in place agreements between, you know, intra-group or with subcontractors, confirming who's got that day-to-day responsibility. So you've got a paper trail for the Home Office if they were to inspect and visit. So I'm now going to hand back to Elliot, who's going to talk about some of the other challenges with sponsorship. Over to you, Elliot.
Thank you very much, Devon. Yeah, so a quick word now on some of the issues that the construction industry has faced when sponsoring non-British nationals. So for skilled workers and global business mobility workers, first and foremost, the challenge is ensuring that they are going to be sponsored in qualifying occupations and that their salary will meet the two respective thresholds that apply to the occupation and to the immigration sub-route itself. So the jobs you sponsor have to be at a particular skill level as stipulated by the Home Office. And there have always been difficulties classifying construction roles as they aren't particularly well accounted for in the immigration rules. Some light relief has come this year in that the shortage occupation list has been expanded to include new roles, meaning that companies can now sponsor workers in occupations that previously hadn't qualified, albeit there are still a number of key roles such as scaffolders and some more junior or more niche specialties which are still omitted and can't be sponsored. We also find on a practical level that when applying for skilled worker visa applications, a lot of workers struggle to meet the strict English language requirement, and the Home Office have shown that even after being lobbied by industry specialists, by industry bodies across the maritime industry, construction, IT, and so on, they have no interest in waiving the requirement, and it remains a challenge that employers are going to have to find a way to navigate, whether that is through, you know, even going as far as booking people into, you know, 3 to 6 month long English courses. We've heard anecdotally that people have taken some pretty serious measures to try and get people over the line so that they can pass a test to then qualify for their visa. There's also the overarching issue of visa fees, which are substantially increasing from this month by up to 50% in some cases, which is going to make the visa process, which is already costly, it's going to make it an extremely expensive exercise, particularly when you're looking at projects where you're bringing in potentially dozens of people or even hundreds of people. The costs really are going to go through the roof. So in summary, the key takeaways really are the importance of understanding the nuances of the employer and employee relationship, as Devon described, within the context of the construction industry, and ensuring that the sponsor is the party with the overarching responsibility for the worker's activity day to day. It's also vital to conduct those right to work checks at the start of employment for all of your workforce to save issues later down the line. And that strong immigration compliance really is essential. You need to commit to the principles of immigration compliance from day one, irrespective of whether you're a sponsor, and ensure that they're upheld for the duration of an individual's employment. Thanks for listening, and I am now going to hand you over to Stephanie. Thank you.
Thank you, Devon and Elliot, and good morning, everyone. My name is Stephanie Giesling. I am counsel in the dispute resolution team in London, and I specialise in construction disputes and risk management. So today I will be giving you a quick run through of some of the key developments in the building safety space over the past couple of months, focusing on the Responsible Actor Scheme, Golden Thread, and downstream claims with a focus on the Defective Premises Act. So starting with the Responsible Actor Scheme, as many of you will know, this was established under the Building Safety Act, and the aim of the scheme is to improve the safety and standard of buildings. It intends to do this by requiring its members to do what is set out on the slide there in more detail, but essentially identify high-risk buildings that have been developed or refurbished in the last 30 years or so, remediate or mitigate the life-critical fire safety defects, and importantly, reimburse government schemes for such remediation. So who is eligible to join the Responsible Actor Scheme? The guidance was published on the 24th of July, which addresses the eligibility criteria. At this stage, developers will be eligible for the scheme if they meet one of the 3 sets of criteria set out on the slide there, and they are not a registered provider of social housing or a wholly owned subsidiary of one. The first 2 categories that you can see deal with developers who have been invited to join the scheme and ultimately should do so for the reasons we will get onto in a minute. These are entities where their principal business has been residential property development, they meet the profits condition, which I will get onto, and they developed or refurbished 1 or more residential buildings over 11 metres in height in England over the 30 years ending on the 4th of April 2022, or they are a developer who meets the profits condition and developed or refurbished 2 or more buildings that have been assessed as eligible for a relevant government cladding remediation scheme. So the profits condition referred to in those first 2 bullet points will be met by any developer whose average annual operating profit over a 3-year period was £10 million or higher. And there is further guidance on how this is to be assessed from an accounting perspective, because there are certain things that you can exclude from that. It is important to note that developers will be treated as responsible for the development or refurbishment of these buildings and therefore eligible for the scheme, even where the development or refurbishment was undertaken by another entity in their company group. So even if the developer itself doesn't meet the profit condition necessarily, if it's part of a group that does, then they might still be eligible for the scheme. The final category that you can see there on this slide deals with other eligible entities, but they must volunteer to join the scheme. So what if you are eligible to join the scheme? So the aims of the Responsible Actor Scheme and the requirements on its members are settled by way of a developer remediation contract, and this is to be entered into between developers and DLUC and is available online. The government has already written to major house builders and large developers back in January, requiring them to sign these contracts if they consider them to be eligible. So what happens if you don't sign up to the scheme? So the scheme is supported by planning and building control prohibitions that impose commercial consequences on any developer who is eligible for the scheme and is invited to join but chooses not to, or indeed does join the scheme but then subsequently fails to comply with the membership conditions. Essentially, these developers will be prohibited from carrying out major developments and from securing building control approval in accordance with the regulations. There is a publicly available prohibitions list that the government has said will be maintained and kept up to date. And it remains to be seen what effect this may have on development funding if lenders are unwilling to lend to developers who are at risk of being placed on the prohibitions list. So the key takeaway in respect of the scheme is that developers should consider whether they are eligible to join and respond to any invites within the requisite timescales. It should also be noted that the government has stated its intention to expand on the eligibility categories. So it may mean that more developers will be called by the scheme in the future. So this should be monitored carefully. The next thing I was going to touch upon was the golden thread. So many of you will know that this was a concept introduced as a measure to prevent similar incidents to that which happened at Grenfell Tower from happening in the future. Essentially, it is the term used to describe accurate, trusted, complete and comprehensive records and documentation for the design, construction, operation, and management of residential buildings. I think it's fair to say that this is one of the main areas where the industry has expressed some concern over the potential cost implications of managing building safety and implementing the legislation for higher risk structures. The estimated total industry cost for the golden thread alone ranges from about £260 million to £450 million. And his estimate is only based on the cost of digitizing and managing the digital information and the digital system. It does not include the cost of actually collecting the necessary information. On the 17th of August, DLUHC provided responses to the industry's feedback on the proposals with the hope of clarifying much of the planned building safety regime. And this included clarifications in respect of the golden thread and what it should look like, which has been met with mixed responses from the industry. The government confirmed that the golden thread of information should be stored and transferred electronically, and has also confirmed the standards that information should meet before being stored, and these are set out in the bullet points on the slide. However, the government has said it will not mandate a particular digital solution, coding standard, or exchange mechanism, saying that they recognise this could create an unnecessary burden in the industry. The government has made clear that it is preferable for the same information management system to be used by the client and accountable person, and they further strongly encourage the use of BIM. The key point will be that whatever digital solution and formats are used, the data should be capable of being transferred throughout the building life cycles, and the information should be usable and accessible at all times. I know some in the industry are disappointed by the lack of clarity due to the government not mandating or providing clear direction on how the golden thread should work. But some have also welcomed the news that it is accepted there's not a one-size-fits-all solution, and that maintaining and storing the golden thread can be flexible depending on the project and platforms available to the stakeholders. So the last thing that I wanted to touch on this morning is downstream claims, and just providing an update on that. So I think it's fair to say the extension of the limitation period under the Defective Premises Act from 6 to 30 years is probably one of the most well-documented and potentially controversial changes brought about by the Building Safety Act. In July earlier this year, the first Court of Appeal decision relating to claims under the DPA since the enactment of the Building Safety Act was handed down. In the interest of time, I won't rehearse all the facts. Safe to say that BDW are the developers and URS had provided structural design in respect of developments procured by BDW. Practical completion occurred some time ago, and BDW entered into a contract to sell individual flats. Following the Grenfell tragedy, BDW discovered serious structural design defects in the developments and accordingly brought a claim against URS in 2019. In 2022, the court allowed BDW to amend their pleadings to include a claim under Section 1 of the DPA. And just to be clear, when it initially started its claim in 2019, it would have been out of time for a claim under the DPA because that was before the Building Safety Act came into force. So there are various elements of this judgment that are quite interesting, but the one thing I wanted to pick out today was the interpretation of Section 1 of the DPA. So on the next slide, you will see that Section 1 of the DPA imposes a duty on those taking on work for or in connection with the provision of a dwelling to see that the work is done in a workmanlike or professional manner with proper materials and so that the dwelling will be fit for habitation when completed. Such a duty is owed in the two circumstances set out in italics there. Essentially, if the dwelling is provided to the order of any person to that person, or to every person who acquires an interest in the dwelling. In this case, the Court of Appeal found that as the buildings in question were provided to the order of BDW, the developer who had a contract with URS for the structural engineering design, URS owed a duty to BDW under Section 11A, so the first kind of limb in italics set out there. It was, of course, already generally accepted that developers owe a duty to subsequent purchases of a property under the DPA. But what this case confirms is that the supply chain can also be liable to up the chain, potentially to the developer. So this will obviously be welcome news to those developers who are now subject to a claim under the DPA, or indeed are concerned that they might face such a claim in the future. So that's it from me today, and I will now hand over to Ryland Ash.
Thank you very much, Stephanie, and the other speakers. And thank you to everybody for joining us this morning. Please spread the word about these fantastic seminars. So I'm a partner at Watson Farley Williams, and I specialize in construction law. And today my presentation is going to be about smash and grab adjudication. This is a broad subject and I could spend a lot of time talking about it, but we've got limited time. So this is going to be somewhat a Bohemian Rhapsody from me. So what are we talking about when we say smash and grab adjudications? So first of all, in the construction industry specifically, we have a statutory right, so long as your contract is caught by the Construction Act in respect of construction operations. And that means that the parties to that contract can at any time bring a dispute to an adjudicator and ask for a decision within 28 days. And that's why it's essentially more cost effective, more efficient and much faster than arbitration or litigation. But it should be noted that this is an interim remedy and therefore any decision made by an adjudicator can then be overturned by a court or an arbitrator. Now in practice, that very rarely happens. I would say less than 10% of adjudications overall end up being overturned because the parties generally accept the findings of the adjudicator. So what's a smash and grab adjudication? Well, I think we're quite honoured to have my esteemed colleagues, Teresa and Stephanie, on this presentation because they were involved in one of the key cases, S&T and Grove, which I'll come back to. And I think they're probably partly responsible for it being affectionately known as smash and grab. Of course, smash and grab sounds a bit nasty, but actually, if you're owed money under a construction contract, it's very much in the spirit of the Construction Act, which says that a contractor or subcontractor is entitled to interim payments regularly throughout the project. Otherwise, the whole thing can fall apart. So when does it occur? Well, it occurs when a payment or pay less notice in respect of an application for payment that's valid has not been issued. Essentially, it's a payment in default. And it's had some quite good press recently. In a case in the Supreme Court, Lord Briggs in Brescoe and Lonsdale, where the subject of the decision was that a party in administration can bring an adjudication. And Lord Briggs was impressed by the process and said that it's a conspicuously successful addition to the range of dispute resolution mechanisms. So he saw the benefits. And then Lord Justice Coulson is a big fan of adjudication, but he essentially says it's the only game in town for construction disputes. On the next slide, you'll see that I'm talking about the numbers. So according to King's College reports, the numbers are rising in respect of referrals to adjudicator nominating bodies who generally nominate the adjudicators for the disputes. And we're looking at around 2,000 a year. But if you compare that to the Technology and Construction Court, you're only getting about 25 cases a year in the construction sphere. So you can see there's a massive difference. You can also see that obviously the majority of construction disputes are being resolved by adjudication. We're also seeing an uptick in adjudications and disputes more generally in construction due to the industry essentially struggling in many ways. The pinch points are in relation to delays on projects, which is generally caused by a lack of quality staffing and labour, resourcing problems that Devon and Elliot have mentioned. We've got inflationary pressures on contractors and subcontractors, particularly where they've agreed fixed price contracts. And you perhaps only need to look at the news and think about HS2 being cancelled to consider that obviously the cost is making some projects unviable. And then you have the ongoing supply chain issues, which are broadly impacted by historical COVID issues and obviously social unrest and wars around the world. And then finally, things like RAAC concrete and other cladding and defects related disputes are becoming more common. So moving on, in terms of the history and the changing landscape here around smash and grab adjudications, I think it's important to go back to really the origin of the opening of the floodgates. And that started really with the ISG and Seepage College case back in 2014, where ISG applied for about £1 million in application 13 for payment. And they sought a decision on the basis that there was no payment notice or pay less notice given in response. And the first adjudication went well, and they got an award for that amount. And then there was a second adjudication by the responding parties on the true value of that same application. And the adjudicator decided actually they were only entitled to 315 grand on the true value. So the problem for the court when it got to court was, well, are they entitled to the 1 million or are they entitled to the 300,000? And what the court decided in that case was that the first adjudication was the one that took priority, and that in fact, by not responding to the application, effectively, the employer or the client had agreed the value. So at that point, it was very much long live smash and grab. And for a contractor or subcontractor, they want it all and they want it now. But the landscape then slightly started to change. So you've got a case here in 2015 where the courts were very much sort of following the ISG line. But if we move to the next slide, you'll see that we then get to S&T Grove, and this is a case that went to the High Court first and then found itself in the Court of Appeal. And this was a very powerful judgment because essentially what Lord Justice Coulson decided was that the reasoning was incomplete and perhaps wrong in ISG and Galliford, and that actually an employer who fails to serve payment or pay less notice is entitled to commence a true value adjudication and reclaim any overpayment, which was great news for employers where ultimately perhaps someone had let them down, either in their team or the contract administrator or project manager administering the contract. But what it also said was that Section 111 of the Construction Act creates an immediate obligation to pay the notified sum, which is subjugated to the right to the true value. So on the one hand, you've got the court saying that you can go for true value pretty much at any time, but that you have to discharge any payment obligation straight away. So at that point, smash and grab started to sort of dwindle. It was an erosion of the attraction of it, really, very much. And so you've got an industry under pressure, and then you've got contractors and subcontractors thinking, well, should I go for a smash and grab or should I actually go for a true value? And of course, the true value ultimately has more value in the sense that it gives a true representation of what the entitlement is under the contract, whereas the notified sum is simply an accounting. And so we come to the most recent case here, which is on the next slide. But before we get there, you can see that in this interim period, we've got Bexheath where the courts have confirmed that you have to discharge the payment obligation before you can go for the true value. And then we get to Henry Construction, which is a case from this year, which said that once the payer has complied with the immediate payment obligation, only then can a true value adjudication start. So there was some uncertainty about whether actually you can start the true value before a smash and grab has been run. And the district judge here sort of made the comment, which I think was revealing, whilst not closing the door on commencing a true value, ultimately you have to very carefully consider the merits of the smash and grab before you go for the true value, because there's no point in going for the true value and then finding out, well, actually you have to pay the smash and grab anyway. And then finally, the most recent case, this Little Great Britain case, where the courts were deciding whether you can link the final date for payment, so when you receive the money, to the issue of an invoice. And what the courts decided was that absolutely no way you can't link the time period between the due date and the final date for payment, receiving payment, to the issue of an invoice. So it's very much sort of bringing the focus back to the entitlement to a smash and grab, the idea that you can't overcomplicate in construction contracts the right to be paid on a regular basis. And so could this mark the return of the smash and grab culture? I think it certainly suggests that it can. So on my final slide, I'm considering what the comparison is and what your rights are. And I think it's important to remember that a true value adjudication will be the underlying bargain under the contract. So that will be looking at a detailed assessment of what you're entitled to under the contract, whereas the smash and grab is very much about the notified sum, which can be right or wrong, so long as you've got a reasonable belief in the figure that's in there. So I think smash and grab is very much alive and kicking, and I expect to see a lot more of those claims. But you can bring true value adjudications. You just have to, I think, assess the risk of the smash and grab first of all. It's also worth mentioning that when you're in adjudications like this, the very key point is to reserve your position on jurisdiction, because if you waive that right, then you won't be able to raise those arguments later if it comes before the courts. So that concludes my presentation. Thank you very much for listening. Please provide any questions and we'll follow up with those. And I will now pass over to Dr. Farshid Bonakar, who's going to be talking about what I would describe as the invisible man of defect claims at the moment, RAAC concrete. Thank you very much.
Good morning, ladies and gentlemen. Thank you for being here. I'm delighted to be here with you today talking about our latest national dilemma. Well, latest until yesterday's our very Prime Minister's announcement on HS2 anyway. Well, I'm going to talk about the RAAC panels in buildings. I'm Farshid Bonakar, a principal engineering consultant and materials and structures RSK environment based in Hemel Hempstead office. Today we are delving into the world of RAAC, trying to address the questions like, why should this matter to us? What exactly is RAAC and how did we find ourselves in this situation? Equally important, what actions should we consider moving forward? The first question worth addressing is why do we have this material used in our most needed built environments, such as hospitals and schools? Well, the answer lies in the weight of the material. RAAC is classified as lightweight concrete, with a density of 600 to 800 kilogram per cubic meter. To have a clear perception about these figures, it should be worth it would be worth comparing it with conventional ordinary concrete, which can be 4 times heavier. There are several ways to make concrete lighter. It of course comes with a compromise to the strength. In principle, this can be achieved by replacing some of the solid materials in the mix by air voids. That can be in the form of lightweight aggregates or introducing air voids between coarse aggregates, which we know as no fine concrete, or indeed introducing voids in the cement paste, which we know as cellular concrete. In cellular concrete, the voids in the cement paste can be introduced by gas or by air or by a foaming agent. Hence these terms as gas concrete, aerated concrete, or foam concrete. Although in various references, gas and aerated concrete can be used, they are used interchangeably. For aerated concrete, this is done by adding fine aluminum powder, which reacts with some chemicals from cement and releases bubbles of hydrogen. Strictly speaking, the term concrete is not quite appropriate because we don't have coarse aggregates or larger aggregates in this mix, but we'll stick to this name for now. Another detail in manufacturing aerated concrete units is autoclaving. The molded aerated concrete units are kept in high pressure steam chambers like these to allow higher strengths at an early age. This makes the unit ready for use typically immediately following cooling after production. With this quick brief, we can now carry on further to our main subject we are here for today, which is RAAC panels, or reinforced autoclaved aerated concrete. There are certain indicative visual features which can help us identify RAAC panels, such as typical width of the panels, which in floor construction is typically 600 millimeter, chamfered corners, the color, of course, when it's exposed, and the softness of the material compared to conventional ordinary concrete, which is typically way harder. So we now know that the aerated concrete was invented to substantially lower the self-weight of the structure, which comes with the downside of a proportionally lower strength. But we are very, very well aware that even a classic conventional concrete is a brittle material, and it's not great in tension. Hence, reinforced concrete was invented to compensate this weakness. RAAC panels follow the same principle, and they use reinforcement. But unlike the ordinary reinforced concrete, the porous nature of aerated concrete doesn't allow sufficient and good bond and grip between the bars and the concrete. Therefore, actually, we don't need to bother going for these ribbed or twisted rebars, which are generally more expensive than plain bar. So we can happily go for the plain bar, cheaper option, same quality, but to compensate the lack of bond between the concrete and the bar, the genius idea of welding transverse bars to longitudinal bar was developed. So a RAAC panel is manufactured in a factory and transported to a construction site and placed on supports to span a floor or a roof. And then when the floor is loaded together with the self-weight of the floor panels, these forces actually push the floor down, which creates two main stresses. One is bending moment, which in this form of uniform load system, that would be maximum in the center of the span. And the other one is shear stress, which in this uniform system of loading, that would be typically maximum near the supports. So in the absence of bond between bars and aerated concrete, the welded transverse bars play a significant role to hold the structure coherent and stable. Therefore, their presence, welding condition, and their position are of crucial importance. So, well, when we focus on, let's focus on one of the supports. Just zoom in here, especially the position of this transfer bar is quite important. This has to sit within the bearing. This is because the shear forces, as we just saw, the shear forces are maximum near the support here. Remember, the concrete is not very strong, and there is no bond between the bars and the concrete. If this key holding anchorage bar would be missing, or the welded connections deteriorate, there won't be much resistance against the shear force. So the panel will extremely be susceptible to hold the integrity of the whole structure and eventually may collapse. That's what happened at Singlewell Primary School in Kent during July this year. And it has been reported that in most of the collapse cases, actually they followed same mechanism. In addition to position of the transverse anchorage bar, that key rebar, the length of bearing is important as well, and shall be considered insufficient if it's smaller than 75 millimeter. This is one of the advices provided by the Institution of Structural Engineering. Pulling all these, in addition to the position of transfer bars, another technical aspect which shall be also measured here is deflection. We measure deflection in relation to the span length in order to assess the level of risk that a deflection can pose to the structural stability of the panels. And again, classify this level of risk as per the guidance published by institutions of structural engineers. So pulling all these together, what needs to be assessed on site when the RAAC panels may be present can be summarized as I have outlined here. First would be a comprehensive desk study, which includes reviewing all the available construction drawings and documents, just to get an initial idea of the possible presence and extent of the panels across a building. Second would be conducting a visual survey to record all the visual indications such as crack pattern, their extent and position, evidence of water leakage, or any alterations after manufacturing the panels or during the operation phase. This can give us an overall picture of the quality of the panels. And finally, carrying out a hands-on investigation using both non-intrusive and also, if the safety aspects would allow, a localized intrusive investigation, which can be very useful, if not necessary. Before ending this talk, I would like to emphasize that the bubbly nature of this aerated concrete doesn't necessarily make it crumbly. I'm using media's term when they report about this national dilemma. This is down to experts to assess and advise whether the panels are at a state when they can pose immediate risk of collapse. Also, we need to remember that replacing roof or floor panels of RAAC construction would be limited, as the associated supporting elements across the whole structure of a building have been designed based on the lightweight nature of the floors. Any changes to the floor system will most likely require various strengthening alteration, or we may actually choose to use brand new RAAC panels, which is perfectly fine, as we have now published a standard to ensure they adhere to certain quality. So, would the current RAAC panels all fail if assessed against the criteria of current standard or course of practice? We don't know, maybe, or maybe not. This needs to be thoroughly assessed in case-by-case basis. This brings me to the end of my talk with a quote from Ralph Emerson saying, "Knowledge is the antidote to fear." So to answer the initial question, yes, we should be worried for so long as we don't have enough knowledge of the exact condition of our floors in the buildings. Thank you.
Thank you very much, Farshid, and thank you to everyone for those excellent presentations. You'll be pleased to know we've got quite a few questions, so I think I'll start with Devon and Elliot, if that's okay. So during your presentation, you talked about home office audits. So what would they actually look like in practice?
Yeah, I'll fill that one. So I've actually sat in on a couple of immigration audits in the past, and actually as an initial point, and it's something that the Home Office guidance doesn't actually tell you, you can ask for your legal representative, if they are named on your sponsorship license, to be present during the audit. And actually the Home Office should agree to delay their audit by around half an hour to give your representative time to get to the office. It may be that if they couldn't get there within that time frame, what would happen is the audit would start, but you could then have the representative join you later on. And although they can't act for you, they certainly could confer with you, and you could then speak to the Home Office and so on. But as for what the actual audit looks like, they would tend to want to interview the key personnel. So your authorizing officer, who has responsibility for the license, they would certainly want to interview them and discuss a range of topics from your recruitment processes through to their knowledge of the immigration system, the number of workers you have. They just want to get a picture that the key personnel know what's going on the immigration license. And I think an important takeaway from that as well is that the Home Office now expects authorizing officers to know their stuff, to know what the immigration system looks like, what the company's doing, and and how it works within the context of the UK immigration sphere. So knowledge is key with that. They can also ask to review company documents. So that could be the information submitted with a sponsorship license. It can also run through to things like bank statements, so that they can corroborate salary payments against visa paperwork. They would go into that level of granular detail. And I think as another point is they would want to they would want to see personnel files, and that doesn't just mean sponsored workers. So that could be British nationals as well. It could be European nationals who have an immigration status in their own right outside the sponsorship sphere. And really what they're doing there is assessing whether the right to work check's been undertaken, but also whether the information you've kept on file is sufficient based on the kind of route that they have, the immigration route that they are in the UK under. So for sponsored workers, they would want to see that you've really adhered to your immigration compliance obligations, and that you've kept adequate records for all sponsored workers. And as a final point, HR systems are something they would also assess. So they'd want to see that you have record keeping and reporting systems in place. So you may quite literally have to sit down and talk them through how you monitor visa expiry dates, how you would report to the Home Office, what your absence management system looks like. It's an intensive process and it can last several hours. Preparation really is the key. If you can get ahead of the curve in that way, there shouldn't be any surprises. Where there are issues are where either corners have been cut or there are deficiencies in paperwork or no paperwork. That's where you're going to run into a world of hurt. As a final point, what I would say, the spot checks are the worst, but if you receive a letter giving you 10 working days before the audit, you at least have some time to get things in order, get the house in order. And typically what the Home Office would do is they would actually tell you in that letter, we want to interview these people, we want to look at these, 5 personnel files and the company bank statements and these documents. So they would kind of almost provide an itinerary of what the audit would look like, so you can plan ahead for that. But obviously they can on the day ask to see additional information. They have the right to really drill down into the information you have on file.
Thank you, Elliot. I'm a bit terrified, but I feel like I know a lot now. So thank you very much. So moving on to Stephanie, we've got some questions through the Q&A for you. Now, obviously, it's been a big week in building safety terms, so yet another big week. So we've had the introduction of the new statutory duties in relation to duty holders, so those performing construction and design works. We've got the gateways regime up and running for high-risk buildings, and the building safety regulator, basically no work starting on site before building control applications have been approved by the BSR. So that's all from the 1st of October. But one of the points in your presentation that's piqued a lot of interest is the discussion of the golden thread. And so really what clients want to know is, will all this information that they're required to keep or would like to keep, will that have to be made publicly available?
So no, I don't think it's envisaged that information will be publicly available as such. Once the buildings are occupied, the kind of key building information and registration information will be published, and residents will be provided with the key bits that they need to have. And there will be the ability to request further information as required, but it's not to say that all the information in the golden thread will be accessible by anyone at any time.
Thanks, Stephanie. And in terms of the eligible member list, so is this just an ever-increasing list? I mean, is this just going to be expanded and become bigger and bigger? What's your thoughts on that?
Without wishing to give a nobody knows answer, I think there has to be an element of that. I mean, obviously, the government's priority at this point is to get, the buildings remediated as quickly as possible, and to focus on the major house builders and large developers who the government feels should be paying for this. And it's targeted those kind of major house builders by putting in that £10 million profit condition. What you can see happening in perhaps a not too distant future is that they lower that threshold to a lower profit to kind of capture the smaller house builders who have, refurbished these high risk buildings in the last couple of years, and make sure that they are captured by the scheme. And that's probably just, to ensure as well that those who the government feels can afford to pay for these refurbishment works should do that without relying on the government scheme. So that's probably where they're going with it from a policy perspective. The other thing as well to think about, obviously the focus at the moment is very much on residential buildings for good reason, but in the consultation phase there was also some discussion around whether this should all extend to the hospitality sector and hotels in particular, and what it means for them. So it might also not, it's not too far, I think, to reach to suggest that perhaps at some point we might also find the hospitality sector being subject to some of these obligations, whether that includes the Responsible Actors Scheme or not, we'll see. But generally the Building Safety Act and the obligations therein might apply to them as well in the future.
Thank you, Stephanie. And moving on to Ryland. So I'm going to stick up for the paying parties for once. So after your description of the Lidl case, does that mean that I can't, associate or attach payment to the production of an invoice? Is that right?
No. So I think the point here is that you can link the due date to certain processes and forms. So you can, as the paying party, say, I want my applications in this pro forma with this information, and on that list you could include an invoice. And that's perfectly acceptable. But what you can't do is then link the final date for payment between the due date to the issuing of that invoice or indeed any other event. I think that it's unavoidable that you're going to have invoices on projects. We need to raise invoices to get paid. So that's inevitable. And of course, I mean, I'm aware personally of a number of live projects, particularly on rail projects, where the type of provision that has been outlawed still exists. So I know that there are a number of contracts out there, probably hundreds, if not thousands, where the invoice is a trigger. And I think those provisions are likely to fail. The downside to having an invoice issued with an application for payment is, number one, it triggers a VAT obligation, a liability, which may need to be adjusted. And the other thing, of course, is that once you get the application, you may then get a payment notice in a different sum, and then a pay less notice in a different sum yet again. So you've got the whole accounting process that follows that, whereby you may need credit notes to adjust what's actually payable by the final date for payment.
Thanks, Ryland. We also got a live question which was asking about smash and grabs and parallel true value adjudications, and I'll just quickly answer that just so we can move on to Farshid. But basically, I think our recommendation, Ryland, chip in if you disagree, would be that you always comply with your immediate payment obligation under a smash and grab before you actually start the true value adjudication, because that position has actually been made a bit clearer by the courts recently. So that would be our quick answer to that one. So moving on to Farshid. So this RAAC concrete story is obviously gaining a lot of momentum. People are very worried about it. It obviously prompted, a lot of children not being able to go to school when the term started again this year. So, whose fault is all of this? Who's to blame for it?
Oh, that's a classic question. Thank you for asking this. Well, we should stop this attitude of blaming, and we need to remember that we are not the only nation, at least within Europe, who is using and had used this form of construction. It was invented in Sweden, so most of the Nordic area countries, they have been using since same time almost. We were utilized this material, also France, Germany, and they are using, they are still producing and manufacturing these elements. Because with all fairness, is a genius idea, is a clever, smart element if it's manufactured correctly, properly, and installed correctly. So whether those cases where we experienced these complications, whether they have been a mistake from a party, whether the manufacturer or the lawmakers, I think that needs to be assessed by a consortium of lawyers and construction experts to sit together and decide on case-by-case basis what was the main problem, whether the manufacturing process didn't happen as it was supposed to, or the maintenance pattern, the maintenance regime did not follow what they were supposed to. Whose fault is this? This is exactly what we need to decide as a group of lawyers, back to the history of a building where this happened, or where this exists. First, we need to establish, is there any problem or not? As I tried to explain within my presentation, having RAAC panels doesn't necessarily mean we have problem. We need to establish this, and we need to find the answer of this critical question first. And then when we establish the problem, a problem within a building, that's when we need to get lawyers involved and back to the history of the construction of that particular building and decide who didn't do their homework correctly.
Thank you, Farshid. I'm afraid we've run out of time, so thank you everyone for attending, and thank you for your questions. If we didn't manage to get to yours, we will respond to you after the seminar. We hope you found this informative. The slides will be circulated to all attendees, and the webinar will be available on our YouTube channel next week. If you've dialed into the webinar, please email events@wfw.com to say that you attended. Thank you very much for joining us.